the law upon which Mazi Nnamdi Kanu is being prosecuted has been read to him. That's the first thing that was done before prosecution commenced. There is no way the judge will even allow the prosecution to proceed with that trial. Plea was taken now. So the question asked Mazi Nnamdi Kanu's lawyers, was there any time anything was read to him in court and he was not asked guilty or not guilty? That law must be read. It's more, that's the judge won't even allow that case to proceed without that thing being read to him.
This is Political Arena, and our conversation with the barrister continues on Nnamdi Kanu's case. You don't want to miss out on the full conversation. Do well to like, subscribe, and share so you don't miss out. This is Political Arena, and you are welcome on board. Now take a listen to his analysis of the case so far. I think there are about 7 charges against him. That 10 counts reduced to 7 counts. Initially it was 10, right? And out of the 7, from what I have here with me, the 7th one is under the Terrorism Prevention Act of 2030, which you say is now repealed, yes, right? The 6th one is still under the same TPA Act, which is now repealed. The 5th one is still under the same one, repealed. The same applies to the 4th one. But then the 3rd one is Nnamdi Kanu. That particular charge is under section 47 subsection 2 of the Criminal Code of Act Cap C45 Laws of the Federation of Nigeria 2004.
That should have been transmitter radio or whatever.
Exactly. So I don't think
even
that has been
Customs and Excise Duties Act as well.
Exactly. So count 3, count 2, and count 1, right, are under the Criminal Code Act of the Laws of the Federation of Nigeria and all that. So if he's saying, okay, there is no law under Nigeria that he can be tried, when you made reference to the Repealed Act, even though you said that even with the existing one that we have, that there is a caveat, if that crime was committed for the purpose of holding that person accountable, that it will still apply. All right. Now,
there's a saving clause in the current law.
Okay.
What we write as a saving clause, it made specific reference to the non-repealed law.
Okay.
Yes. So what my concern has to do with the issue of punishment. You cannot award any punishment that is higher than the punishment that was in vogue at the time the criminal act was allegedly committed.
So what is the punishment for the crime he's been accused of in the now repealed act?
There is no uniform punishment. It depends on the degree of the act of terrorism perpetrated.
So it is at the discretion of the court?
No, not discretion. I say it depends on the degree of the act of terrorism. That's why I made a comment earlier that I wouldn't know under which ambit he's being prosecuted. But I know that either under the repealed act of 2013 or the current one, that if the act of terrorism gives rise to the death of citizens, then the punishment will also be death. Or both under so I wouldn't know they are charging under that particular provision. Okay. So there are instances whereby if maybe from your utterances you fomented strife without necessarily giving rise to death. There's one whose punishment is 20 years. So the punishments differ based on the degree of the severity of the consequences that emanated from the alleged act of terrorism. That's what I'm trying to say. No, so the maximum is death under both the repealed law and the current law. That's why I say that if part of the charges that one sustained include the allegation of same causing, giving rise to death of people, then the punishment is the same whether under the repealed one or under the current law.
Okay, so but how about the criminal code of the criminal code? Yes,
it has not been repealed.
It has not been repealed.
Yes.
So how about the charges leveled against him under that act? Can it stand? So how is it possible for him to defend those ones and say, oh, the repealed act or the charges leveled against me based on this repealed terrorism act cannot be defended?
No, is that possible? Any single charge that is valid suffices.
Okay.
If about 10 different counts are brought against a defendant facing trial, even if only one is valid, in law it can sustain that prosecution. Only that the ones that are not valid at the end of the day will be thrown out.
But in this case, this 2013 is still valid from what you're saying.
Yes.
It's still valid. The Repealed Act.
It is still valid in the sense that the current one specifically made reference to it and brought it to life. And let me throw more light on what I said earlier. with due respect, the question being asked the learned trial judge is like a rhetorical question. If you are not saying that, look, you are charging me, you are prosecuting me pursuant to, but I'm being prosecuted pursuant to a strange law. It's a different issue. Or that this law upon which I'm being prosecuted is no longer valid. It will not just go that way. It will be a matter for address.
But is it not incumbent on the judge to read to him that this is what is obtainable in the recent?
No, the judge is an arbiter.
Okay.
A disinterested third party. That question ordinarily should be directed to the prosecution.
Okay.
And they don't even ask them that question in court because they have already brought their case against you. Whether they framed any law or not. But I know that in law, before criminal prosecution will be ignited, it must be based pursuant to an existing law. The validity of that law, otherwise, it's a different issue altogether. Because even before information will be charged, will be framed, the information will be couched in such a way that it said that law must be mentioned there. Its legality is a different issue altogether. Okay. You can, during final address, now draw the attention of the court, the judge. That's what you now tell the court, my lord.
It's the job of the prosecution to highlight
exactly, to initiate proceedings pursuant to a particular law.
Okay.
That of the judge is to stay aloof and watch.
Oh, okay.
If at the end of the day the defendant now believes that this law is invalid, it's now during final address.
So, is it safe to say that Nnamdi Kanu is hoping that the judge does not know what is obtainable in the new Terrorism Act?
A judge is presumed to know the law, and with due respect to, I know that the judges is during their judgment that they know the law.
Because he's challenging the judge. If you listen to the court outing, I think the other wasn't the last time or second to the last time that he was in court, he was like, there is no valid law. If there is any, you, my lord, should read it to me. This is Nnamdi Kanu now to Justice Omotosho. So and I'm like, okay, is it in the place of the judge to tell him that even though the Terrorism Act of 2013 has been repealed, look at what the new act says? I don't know if it's
not the duty of the judge.
It's not the duty of the judge.
And secondly, the law upon which Mazi Nnamdi Kanu is being prosecuted has been read to him. That's the first thing that was done before prosecution commenced. There is no way the judge will even allow the prosecution to proceed with that trial. Plea was taken now. So the question asked Mazi Nnamdi Kanu's lawyers, was there any time anything was read to him in court and he was not asked guilty or not guilty? That law must be read. It's more, that's the judge won't even allow that case to proceed without that thing being read to him. And that's why even those who don't comprehend English, they first of all ask you, do you understand English or Igbo or Pidgin? If you say that even though I understand English, I want Igbo, in law, they must read that criminal charge for you, the charge against you in English and interpret it in Igbo, and I ask you, are you guilty or not guilty? So he took his plea. Before the prosecution was now called upon.
So the argument that there is no valid law upon which is being tried
should be a matter for address.
Should be a matter for address
at the end of the case.
So for the plea to have been read to him, he has to enter his defense.
No. Defense is not a must.
Okay.
You must not be compelled in law to enter your defense, but you must be given the opportunity. In fact, because the principle of fair hearing. If there is any room for a defendant to allege that he was prevented from or he was denied the opportunity of defending himself, it can be a ground upon which the trial will be quashed on appeal, no matter how good that trial may have been conducted. And considering the nature of the criminal charge facing him, ideally he's entitled to the service of a lawyer. But if a defendant who is facing the type of criminal charge pending against him decides not to be represented by a lawyer, there is a duty incumbent on the judge too. Keep hammering on the fact that, look, you are entitled to the service of a lawyer. And that's what this judge is now doing. Trying to emphasize that you are entitled to the service. Go and look for any lawyer of your choice. But if you say that I don't need the service of any lawyer, you cannot hold the court to ransom. The court may extend that period of grace, allow you, so that, please, the court may even say, I advise you, look for the service of a lawyer. So that tomorrow, if you now want to raise the issue, you can raise any other allegation. But the allegation of denial of right to fair, the right to fair hearing is not absolute. Otherwise, our cases will not go on. Otherwise, if I'm being told to enter defense, then I will not go back home and say, I will not hire any, I will not say anything. If you don't say anything, and you are being given an opportunity to do that severally, the court will now act based on the evidence before it. And the interesting thing about criminal jurisprudence as opposed to civil suit is that in civil cases are won based on the balance of preponderance of evidence, balance of probabilities. That's why the Lady Justice, the symbol of justice, I don't know why the goddess of justice is a woman, with the scale of justice. So in civil suits, both the contending sides, they place their respective pieces of evidence on that scale of justice. Whichever one weighs higher, the court will strike. But in criminal jurisprudence, it is proved beyond reasonable doubt. Even though not proved beyond all iota of doubt. Having said that, even when a defendant does not defend the case brought against him, it does not automatically mean that he'll be convicted.
Okay.
So there is still possibility that the defendant who fails to defend himself can still be set free if the evidence adduced by the prosecution, even if prima facie, does not establish a case of proof beyond reasonable doubt. Because now the court has held that a prima facie case has been raised,
established
against man, and that's why the court called upon him to enter his defense. But let me make a general comment. It does not mean that once the prima facie case has been made out against the defendant, that then the defendant must be convicted. The court also has to go back to that evidence, and also marry same with what happened during cross-examination. Because if you make out a prima facie case against me, but during cross-examination, the adverse party may whittle down the strength of your evidence. During cross-examination, the strength of that evidence given may be watered down.
Are you looking for the word agada, Chris?
So during cross-examination, the prima facie potent evidence may be
watered down
by the adversary. In which case, if the defense team is able to raise some form of doubt with regard to the evidence given by the prosecution witnesses, the defendant will not be convicted.
Now, listening to his lawyers speak yesterday after the court outing, they're trying to put up an argument because Maxwell Okpara is saying that Nnamdi Kanu is not saying that he is not going to enter his defense, but he is saying that they should point him to the law upon which he is being tried. So I don't know what...
That law is available. You can even get that law if you like. If you apply for the certified true copy of the information filed against you will see the laws upon which it's being
tried. I think the argument they're trying to put up is that law does no longer exist.
It should be a matter for address.